Hello and welcome to PM Express. Now, with few days to the 2024 presidential and parliamentary elections, the Electoral Commission has disqualified Joanna Cudjoe from running as NDC candidate for the parliamentary elections in the Amenfi Central constituency of the Western region. Now, this follows a petition to the EC claiming that there is a pending order of interlocutory injunction restraining the commission from recognizing Mrs. Cudjoe as the parliamentary candidate for the party. Now, it came after a successful filing of nomination forms by the candidate Joanna Jan Cudjoe, who was re-elected by delegate following an annulment of primaries conducted earlier this year. Now, let me share with you details of the letter from the Electoral Commission to Joanna Jan, communicating the decision by the Electoral Commission to her. Now, it says, I bring you greetings from the Electoral Commission and trust this letter finds you well. Now, the Commission's attention has been drawn to an order of interlocutory injunction dated 31st May 2024 in respect of a suit entitled Jedu Frimpong and 4 others versus Joanna Jan, the National Democratic Congress, and the Electoral Commission of Ghana, with suit number E123624 by the High Court 2nd D, and the orders states as follows. So these are the orders that this interlocutory injunction has in them. Now, the order, there are 2 orders there. Now it says A, defendant or respondent, or the order is that it is ordered that until the final determination of this particular matter, or the substantive matter, the affected parties are restrained as follows. A, the defendant or respondent for holding herself as the duly elected NDC parliamentary candidate for the Amenfi Central constituency. So this is where, this order is seeking to then restrain Joanna Cudjoe from holding herself out as a legitimately elected parliamentary candidate of the NDC in the constituency. It again says the second and third defendant, which is the Electoral Commission and the NDC being the second and the Electoral Commission being the third defendant or respondent, their agent and officers from holding out, allowing the first defendant or respondent to be held out, dealt with in any way, recognized or afforded any right or privileges as the duly elected parliamentary candidate of the NDC for the Amenfi Central constituency. So this is what, the petitioners or those who took this case to court are looking for. The said order has neither been stayed nor vacated. Hence, the commission is bound by same. So this is, the premise the EC is basing its conclusion on. In this regard, we write to inform you that you have been disqualified from standing as a candidate for election to parliament in your constituency. This is what is coming from the Electoral Commission. And a lot of people have been reacting that, well, does an interlocutory injunction qualify as basis enough for the Electoral Commission to disqualify Joanna Jan Cudjoe as the NDC's parliamentary candidate for the Amenfi Central constituency? We explore this particular matter. We explore all the reactions. We speak to the party, the incumbent MP, who is now running as the independent candidate in the constituency, and also speak to a lawyer for some education on this particular matter. Yeah, on PM Express. Please do stay so we all get this education together. All right, so welcome back from the break. This show is brought to you by Syntex Tank, and Syntex says, Ghana, get ready for the biggest giveaway from Syntex Tank. Syntex is visiting 15 communities, giving them free water. This is to say thank you, Ghana, for making them #1. Syntex is the first to introduce double-layer tanks in Ghana, and you also know that Syntex Tank come in so many colors and was first to come out with inner white layer. So when it's not Syntex, forget about it. Now, if you're a community and you want to benefit from Syntex free water giveaway, just log on to their social media handles at Syntex Ghana and nominate your community. The more you nominate, the better the chances of Syntex coming to your community. Remember, it's Syntex Tank. No be any tank, we be tank. Syntex Tank. strong, tough. Now, let me go on to the line and start talking to my guests. We have Peter Yao Kwachiaka, who's MP, Amenfi Central Constituency. We have Mr. Fagbande, he's NDC Deputy General Secretary. And also, we have Samson Ladi Ayanene, he's a private legal practitioner. Samson, grateful to you for joining. Let me start with you. Now, is an interlocutory injunction strong enough for the EC to arrive at this conclusion?
Could you, from what it appears, the EC, it would appear, has obviously erred in a very big way.
Okay.
An interlocutory injunction is not a final order of a court. An interlocutory injunction is not a perpetual injunction, which is granted as part of the judgment, with judgment being the outcome of a case. It is a provisional order. What it means, therefore, is that it does not determine
I'm on Joy News. Joy.
It doesn't determine the rights
you can watch it.
of the parties as far as the outcome of the case is concerned. So if there was an interlocutory injunction in May 2023, is that what the thing says? In May 2023, that interlocutory injunction restraining the parties that it restrains could, in the end, those parties that have been restrained at the end of the case may emerge victorious.
Okay.
If they emerge victorious, it will mean that that injunction has no effect on them. So it is difficult to appreciate why the EC says, because there is an injunction, you have been disqualified. Disqualified on the basis that there is an injunction.
Okay.
But Kojo, it gets bad when you discover that this election that was held in May 2023, May 13, which is the subject of the injunctive relief, was actually annulled by the party September of 2024. And a fresh election was held on the 8th of September 2024.
Yeah.
That fresh election, guess who supervised it?
Electoral Commission.
Electoral Commission supervised that election and declared the woman, Joanna Kujo, as duly elected or affirmed because it was an acclamation. Now, the EC, is the EC saying it was not under a restraining order at the time when it supervised that election? The injunctive order related to the May 13, 2023 election. That May 13, 2023 election has been annulled and a new election conducted on September 8, 2024. The suit in court relates to the election of May 13, 2023. The suit does not relate to the election of September 8, 2024. Please, do you get what I'm saying?
Sure, yes.
Right. So it sounds absurd, very strange, that the EC will come to the conclusion it has come to, and I respectfully say that it has been ill-advised, and it appears to have been in a hurry to issue a disqualification order, and in this circumstance should have X on its face. So you say that, imagine that the injunctive order was still subsisting. What if the injunctive order is vacated today or tomorrow?
Okay.
Because an injunction order is liable to be vacated. Supposing it is vacated tomorrow, what would you say? So it does not lie in the mouth of the EC to say, because I am aware of an injunctive order, you have been disqualified. Okay. Now, the EC again needs to check its own rules and the laws on the incidence of disqualification. What is it that is a ground for disqualification? Does it include a circumstance as this? But first, I've explained to you that by what I have checked, which is available in open source.
Yeah.
You just Google and you find all the information there.
Yeah.
The suit relates to an election result of May 13, 2023.
Yes.
That election was annulled. And then a fresh election was held on the 8th of September, supervised by the 8th of September 2024, supervised by the Electoral Commission, and the Electoral Commission declared the person who is being disqualified today as having been duly elected or affirmed.
But lawyer, in that particular election of May 13, 2023, and when the party was annulling the results, Fifi Kwete, and I quote, he says, in the relief C, D, and E of the plaintiff action, they seek from the court the annulment of the parliamentary primary elections results and an order for rerun of the elections. He then noted that the Functional Executive Committee of the party at its meeting on Tuesday, 3rd September 2024, decided to annul the election and rerun same. Does this action then, cancel the action at the court such that then all the parties who are bound by that particular action are free to engage in any action that they take thereon?
The decent thing would have been that the annulment, since it was part of the relief that was being sought by the aggrieved party, would have become a subject of terms of settlement, which would now had triggered a withdrawal of the suit or a decision of the court affirming that settlement as the judgment of the court. But remember something that is essential. What is essential is that there was an injunction order. The injunction order or the suit related to an election of 13th May 2023. There is no suit relating to and concerning an election of September 8, 2024. That for me is a substantive point.
Okay.
And it is not for the EC to proceed in the manner that it has proceeded. And I mentioned to you at the start that such an injunctive order is a provisional order. It does not determine or conclude a matter. So for you to on the basis of that interim order, that provisional order says somebody is disqualified, it sounds to me as an overreach. It sounds to me as an unlawful conduct, really. And supposing they went to court tomorrow and they vacated that order, and the court declared that that order had been vacated, what is the EC going to say?
Okay.
So I think the EC is bringing a problem onto itself, and you can imagine that they will not take this lying down. They would take steps. They very obviously will issue a process, and they may in that process even add an injunction which will most likely stop the EC from proceeding with what it intends to do immediately and stall its processes. And again, I am surprised that at this time of the year, getting to the elections, there is any suit concerning or related to elections pending in the court. Because I came out of one, of such a, process, and we knew that the orders of the judiciary, the directives of the judiciary, were to judges who were handling any matters relating to elections to be fast about them and dispense with them, quickly, so that by the time of the elections, there will not be any case pending before the courts. So how did it happen that this case was still pending in the courts?
Okay. So can't it also be, or can the EC use probably the time for the printing of the ballot as probably a reason to have arrived at this?
Look, in fact, imagine if it were, you cannot have a perpetual injunction even in such cases against the public right. Okay? So this is bad. Let me tell you for a fact that it is bad. And the fact that the EC is going to print, is going to issue notice of poll, I suppose that's what is going to issue, and accompanied with the printing of the ballots, as you say. Would you rather do things, properly so that you don't have legal obstacles to that process, or you do them in a way that will attract legal obstacles that, stop you and prevent you from proceeding with such things?
Well, it means that we should be ready for a long legal battle if nothing changes by tomorrow.
Obviously, they won't take this lying down, and it is such an overreach and an interpretation of the law in a manner that I say is rather bizarre.
Okay. I'm grateful to you, Samson. Ladia Yanini is a private legal practitioner. Let me bring in Mustafa Gbande, who is the Deputy General Secretary of the NDC. Mustafa, how's the NDC taking this?
Well, I think good evening to my best friend, Samson, and yourselves, and also to Honorable Kwachiaka. Basically, we foresaw that Honorable Kwachiaka was on the path of holding the party to ransom. And what he has done this evening is to let President Akufo-Addo off the hook of statements he has made, which the party would have used the opportunity to digest. That is what he has just, apart from that opportunity, I think that, one, as Samson has indicated, Mr. Kwachiaka was uncomfortable with a previous election. He demonstrated considerable amount of, rejection to any proposal that the party will put before him in terms of reconciliation. The Western caucus of the party have engaged him. The national chairman was in his constituency to engage him, and each time he was engaged, he pretended to be okay, only to go back behind the scenes and begin navigation. You went to court, incited people to go to court, came back and pretended that you were not involved. Now the party nullified the previous election. You knew that you had a matter pending in court, but you participated in the election. You actually picked nomination form, except that Mr. Kwachiakra was in the dilemma of having forged signatures of party delegates who are required to endorse his form. And I think he admitted this afternoon.
No, but Mustafa, this has gone beyond him, right? Now the Electoral Commission is
No,
the one.
No, it hasn't gone beyond him.
Okay.
As Samson, I need to let the fact stand.
Okay.
That the only reason why he probably would have not won the subsequent election was because he forged signatures and subsequently withdrew. But if he had won the subsequent primaries, will that order be sent to the Electoral Commission to the effect that Joanna Jan Kujo should cease to be qualified or eligible to stand in that election? No. You know, so, and I have said that the decision by the commission is an error. Probably if the commission had averted and engaged with the party, it would have been given further and better particulars to be aware that the application of applicants, aspirants to the commission did not have the records of the previous election because that election was annulled. And so in this subsequent one that we held recently, which Mr. Kwachiakra participated, there is no suit, there is no any embargo on that election to the effect that you should be disqualifying candidates without discussing. Mind you, I think the Electoral Commission is on the path that want to undo itself so that because it is not prepared, it should have an excuse not to hold the election on December 7th. Goma, Cynthia Morrison, a similar incident have happened. The Electoral Commission goes ahead to write to her that she is disqualified. A sitting member of parliament who have decided to go on independence, you write to disqualify. So I think it's very unfortunate. But in all of this, there's Mr. Kwachiakra, Honorable Kwachiakra, who have decided that he wants to hold the party to ransom. And I can assure him that he has just started a battle with the party and the party will take him on.
So I wanted to find out what the reaction of the party is to the EC's decision to disqualify your candidate.
By tomorrow, I think that the flag bearer is in Accra. The national chairman, unfortunately, is around. The general secretary is himself around. Party leadership will meet around it and give it the necessary attention that it deserves. It's not an issue that the party will let go. And so the EC has put himself in a position where I'm not sure whether it will be able to hold a Amenfi Central election on December 7th. We will pursue the matters in court to its final conclusion. Then we can take it up from there because we believe strongly that the party is fortified with the power to qualify eligible applicants who apply to contest election within the party. The processes were followed and disagreement ensued. The party went ahead to deal with that disagreement. And we believe that as party members, that should have been the end of it. Mr. Kwachiakra has been very apprehensive.
But I wonder why you are trying to draw him in, because his name is not on the writ. The writ has different names than he, as Peter Kwachiakra.
No, we know that Kwachiakra is behind it. He met with the Council of Elders. He is aware. And you should ask him whether he forged signatures or he did not. You know, the people who are in court are all his people. Ask Mr. Kwachiakra whether I was in his constituency or not. Ask him whether the national chairman was in his constituency or not. We know who are behind all of this. When he went to see some officials to reserve him a form, we are aware. What is he talking about? So he cannot run away from something he has cooked, seeking to benefit from it. according to his own words, you can't eat your cake and have it. And so the party will not let itself down. What Kwakyaka has succeeded in doing is to muddy the waters this evening, excusing President Akufo-Addo to national accountability of his comments and the things that he's been speaking of in during his talk. That is what Kwakyaka. The party is not perturbed.
Let me bring Peter Kwakyaka himself in, the Honourable Member of Parliament for the Amenfi Central Constituency. Mr. Kwakyaka, I'm grateful to you for joining. Now, I mean, we know that the May 13, 2023 election results were annulled by the NDC. Why was this case still in court? Kindly unmute, sir, so we can hear you. Mr. Kwakyaka, kindly unmute so we can follow what you're telling us. All right. So we're trying to get the MP for Amenfi Central, who is now running as an independent candidate, to let us understand more about this particular issue. His party is accusing him of being behind all the legal tussle that is now.
Can you hear me now?
Okay, good. I can hear you now, sir. I can hear you now, sir. Yes.
Okay. Yeah. Good evening to you and your cherished viewers and listeners. And I greet my very good friend, Bandon. Anytime he talks to me, I think it becomes too personal. And the lawyer, Honorable Ayini, I'm very much privileged to be on your show today. In fact, I never thought that this was going to be the topic for discussion. I think I would have reclused myself from this because, as I say, maybe I'm an interested party. But it's unfortunate. My very good friend, Mustafa, has personalized the issue. I mean, the question on the table is not to me as a person, but all he made was just to denigrate me as a very bad person, as a uncompromising person, all that. I think this is not the first time we have spoken, and anytime he tries to attack my person, I'll go straight to the question on board, especially what the lawyer alluded to. I think I'm not a lawyer, but my personal view is that the court, which I'm not part of, the petitioners, I mean, Mustafa Bandil cannot tell me that he has not got friends, that if something happens to him, people will not, for his sake, go to court. I mean, this is normal, especially in politics. I've been an MP for 2 terms, so definitely I have friends. People have helped, people have supported and all that. So if something happens like this, you don't doubt that you'll get people to go to court, maybe on your behalf, because to seek your interest. But that doesn't mean that I'm the one that has gone to court. But every time he insists that as if I'm in court. But I think if I listen to the lawyer, he was making a statement. I will say that the injunction stated that there should not be anything to deal with the PC until the final determination of the case. Until the final determination of the case. Okay. And can we say that is the case settled? I think the lawyer, eminent lawyer, also stated that he was surprised that the case was still in court. I think that is the hitch. Why is the case still in court? Because he said that because of the elections, this case should have been finished long time ago. I think that's what the judiciary has decided.
But again, exactly. If you knew that the entire case had not concluded, why then did you, as an individual, avail yourself to be part of the second process to elect a candidate?
No, I have not taken the matter to court. So whatever the court is doing has nothing to do with me. I think you must know that you are talking as if I've taken the matter to court. No. I myself engaged.
No. I'm only asking the question based on what you said, that the petitioners were asking for the EC and all parties involved to restrain Mrs. Jan from holding herself as a PC and also from conducting any processes until the final determination of the case. And I'm asking, the case had not been finally determined, but the party went ahead to annul the result and conduct a fresh election, which you participated in until you were disqualified.
No, the court did not put any sanction on the party not to conduct elections or not to. The court said you should not have anything to do with the subject. That was what the court said. So if the party, which I belong, is conducting the primaries and I decide to go in, we have not faulted at all, because the injunction says that they should rather not have anything to do with the PC at that time. That was the court directive, and not referring to that nobody should have anything to do with the party. So if I participated, I never faulted at all. So if you ask that question, I think it was rather if the party, knowing the injunction, went ahead to have something to do with the subject. Maybe that's the bone of contention here. But for me, if we are going to conduct elections and I decide to participate, a party of which I'm part, I mean, I didn't wrong at all. I didn't do wrong at all.
Wasn't it part of the release being sought by the petitioners that the election results should be annulled?
Well, I think there were a lot of reliefs sought, and that could be one part of it. I think I should have revised my notes before coming, but it could be part of it. So, but that will not be all the reliefs.
Exactly, I understand. And I'm saying that once the results were annulled, fresh elections were held, and you joined that election, isn't it?
Yeah.
So.
But who knew that even they were going to have something to do with a candidate who was in court for that reason, for that matter? Who knew? So if the party says they are not going to conduct fresh elections, maybe I would think that no, that subject matter, that subject will not be part of the new arrangement. Unfortunately, she was part of it. And as she said, I was disqualified. And then the only candidate was the person who was in court, and then he went and the popular acclamation was acclaimed. But I say that because if you have done that, it doesn't release the court injunction. It doesn't at all. The court injunction, I believe, is still there. So if anything at all, I listened to the lawyer. He said this new arrangement could have been taken to court. For the court to now accept that one, based on the participation of the petitioners and the other subjects, to go to the court and settle the matter there, that, well, we have all agreed on this one. We have conducted fair elections. Now we have come out with a victor. And so both parties have agreed. So court, we want you to take this arrangement, which all of us have agreed to, so that you will strike out the injunction. I believe that as a layman, that should have been done. That if the court had released, cancelled the injunction, then that would have been better. But if the court is still holding on to the injunction, and the EC being told that it should not have anything to do with such a subject, I believe that maybe that is the reason why the EC also took the decision. But if they had taken this arrangement back to the court, for the court to accept from both parties, and then that arrangement was taken to the EC, that the court has not accepted the arrangement that we made, I think that would have been better. But if there's injunction and you just stay in your corner and then you conduct fresh elections and believe that the injunction is out, I don't think that is a right thing to do, in my opinion. Yes, because the court said until the final determination of the case, and the case has not been determined. But rather, I used to follow, because I have interest. I used to follow the court proceeding, even when I was in the States. I used to follow every proceedings. I used to follow. Most of the time, the court instructed that they should go and settle the matter and bring the case back to court. I mean, if that had been done, I believe that the judge, in his own wisdom, was trying to tell the parties involved to go and settle on an arrangement, to come to an arrangement, amicable settlement, agreed by both parties, and then taken to court for the court also to accept that. That was never done.
That wasn't done, you mean?
Yes. As far as I know, there's no agreement. There's no arrangement to that effect, which the court will stand on that and say that, no, you have agreed, so I'm going to take out the injunction. I believe that that should have been done. Even if the election had been conducted and you feel that all the parties, aggrieved parties have agreed, not me, because I never took the matter to court. Even though I have interest, I will not deny that. But those people who have taken the matter to court should have agreed on your settlement. That, we have conducted special elections. You know that this is the result. So please, sign the document. We take the document back to court for the court to take the injunction out. So I believe that should have been done. If that is not done, then I feel that the EC, basing the argument on the instructions of the court, that the court has not advocated the case. The injunction.
All right.
The case.
I'm grateful to you. Stay on for me. I'll take a very quick break. When I come, Bande, you'd have to answer for us why the party did not go into a settlement with the parties involved. Stay on here. This is still the PM Express. Welcome back. Mr. Bande, let me bring you in. When the court, asked that parties go and settle and come to an amicable conclusion, what did the party do?
Well, let me start by saying that the party still believe that the mechanisms to completely deal with conflicts will be deliberate reconciliation. So even though a subject matter had extinguished, there was a need to still use backdoor to engage individual parties involved.
But was the court made aware of the conclusion that you've come to?
I think so. I would consult to the legal department. I think that Mr. Kwasi just said that he doesn't know anything about. I can give you videos and audio recordings of his voice where he was instigating people, conversations he has had with people within the judiciary. I have all of that on my table. Even now, when we went on break, you've heard what he said. I'm going to request for the transcription of this interview, and you will see how he has exposed himself. And so people do things in the dark and come to the public and pretend. Pachiaka is a pretender. He wants to hold the party to ransom. That is his deliberate action, and he has done so. But I dare say that no individual can bring down a political party. It doesn't matter what it costs the NDC. Who take him on? It doesn't matter how relevant he is in the scheme of things. The party will take him on. That assurance I will give him. If you forward this transcription of the recording to him, he will feel embarrassed by what he just did. And I think it's a dishonorable and despicable attitude by people who ought to know. Look at the kind of things he was saying. Look at the kind of conversation Mr. Pachiaka was having with a third party. And I'm going to compare some voices and see if it is not the same person he was engaging in the judiciary with. I think we stand to expose people like this
hold on, Bande. If you say he was engaging in a conversation with someone in the judiciary, what do you actually want to say?
What I mean is that if he pushes us, and by tomorrow, we'll begin to release conversations, backdoor conversations of Pachiaka with people within the judiciary.
To do what? To do what exactly? What was he asking them to do?
No, he's pretending to you that he doesn't know about the case. It's bare fact lies. He's lying. He's telling lies. Completely falsehood. And I'm saying that even right now, he forgot to mute his audio, and everything he was saying, we're all listening to. You heard it. Samson would have heard it. And when you listen to that audio, you will know that he just sat on television and lied to the Ghanaian people. He just sat on television, opened his mouth and lied. He is behind this conspiracy, and it's a grand conspiracy because Kwachiaka has lost election, NDC must break. kind of thing is this?
Okay.
You talk anyhow to party leadership and you are a member of parliament and you expect to be on the same party? What kind of attitude it is? So the party have taken judicial notice of his conduct and actions that he has advanced, plus what the EC have done. Party will advise himself in due course.
Okay, all right. But if it comes that he will be your only hope because he's running as an independent, he's there, won't the party work with him?
Let me give you the assurance that Kwachiaka will not be the hope of the NDC. He's a despicable member and the party will deal with him as such.
If your candidate does not get onto the ballot, who becomes your hope?
Unless, of course, you want to tell me that there is any iota of facts to prove that Kwachiaka will win the case in court. But as far as I'm concerned, I don't see how the party erred.
Okay.
I don't see how the party will take a member who doesn't qualify to be a member. Kwachiaka doesn't determine how the party is run, and the court doesn't determine how the party is run. The court will rule in accordance with the constitution and processes of the party. This is what the court will do. The court will not manufacture the facts beyond what they are. So I don't think that the party will lose the case. I just think that it is a fatal error for EC to have taken the position it has. But we will fight it decisively.
All right. Grateful to you, Mustafa Gbande, for joining. Mr. Kwachiaka, let me give you 30 seconds to take your part in comment. What would you do now?
I think next time I wouldn't like to come on a program with Mr. Gbande because
because I've exposed you.
Please,
because I've exposed you.
But Gbande, please allow him. Give him time for him to speak.
Because he doesn't know how to talk. He doesn't respect, and he talks anyhow. And I think it's unfortunate. This is a very big platform, and look, all his this thing is just against me. I mean, he's got this thing against me, and I know the reason why he's taking me on the whole program. I mean, let us discuss the issue at hand dispassionately. And yet, every time he opens his mouth, it is against me. At one time, I heard him on another platform saying that the party has made me. Yes, I don't dispute it at all. But I think I always say that I'm grateful to this party for giving me the opportunity to become popular in the country. That's all.
Okay.
But before I came to the party, you must know that I was not a beggar. I was a chief engineer, and I was earning good money. But that notwithstanding, nobody knew me. And for this party to have given me that opportunity to become a DC and then an MP, I'm most grateful. But he should stop always going around and saying that the party has made me. The party has not made me that human being before I came. So sometimes he should not go personal. It is too personal, whatever he says. During the break, what did I say? A friend called me. He says, no, Mustafa is trying to intimidate me. I said, no, I know him already. I know the way he behaves. He will try to talk like that, but I will remain calm. I told me, if you heard me, I said, no, I'll try to remain calm. I will not say anything.
Okay.
But that's what I said. And he's trying to make it as if I've said something which is unpalatable. I mean,
Mr. Aka.
This still is not good at all.
I wish you all
next time, please.
Okay.
If you want to bring me on the platform,
we shouldn't pair you with him. All right. Grateful to you.
I wouldn't like it because he talks just disrespectful.
Grateful to you for joining us here. This has been PM Express. My name is Samuel Kojo Brace. On behalf of the production team, thank you for doing the watching. We'll meet again, God willing. Good night.